what you said there about the birth certificate is made me think it's like the title to our automobiles, huh?
Yeah, that's right.
Okay.
We never expressed that to be a trust. We never made special deposits. That put us back under debtor creditor for them to run the show. It's just like if I drew an upside down T account. Left side I got minus, which is the public side. The right side I got plus, which is the asset side, which is private, the private side. So public and private. And then at the top I drew like a smaller circle, which would be, say, like the trust or the straw man trust. So then on the private side, I have another circle, say, I'm going to put represents, say, a T in there. That's the title. The title of some assets or an amount. Then on the left side, the public side, another circle with another T in it, which represents the title of a liability. So now I'm going to move both titles from one side up to that top circle, that trust, put it in a special deposit, move that title from the other side into that circle, and now I've got an equal amount of minus and plus in that trust, and that's when the discharge takes place. So the minus discharges the plus, or the plus discharges the minus, whatever it is. When they're brought together, when the two titles are merged together in that straw man trust, the debt discharges to zero. And here all along we thought we were setting off, and we weren't. We weren't doing house joint resolution. We can't do a set off and do house joint resolution on the public side. We've been doing that all wrong. The discharge occurs only under trust, when you merge the titles in a trust. When you merge that title, then that trust will terminate.
I don't dig the reception, no.
Because there's no purpose for it left. So if that just represented a court case, I would be creating a court case title on one side with a counter court case title on the other side. And the case itself would probably be the trust, and I would merge both of them together, and that would zero it off and discharge it through trust. Now the question is whether I set myself up as beneficiary or whether I'm still trustee. If I did the individual master file correction, or if I didn't, I could play it either way.
It looks to me like as trustee, you could maybe command it more.
Yeah, well, I'd be in more control, maybe as trustee. But then if it's a discretionary trust per the bankruptcy trustee, then he may withhold and use his discretion to withhold. But then I could do the 1099 OID refund, and when the IRS got a hold of it, then once I got it back, then I would give the order and instructions to apply that to the debt. Therefore, the creditor's been paid. And if I get that early enough, probably wouldn't have to be in court.
Right.
So I think we have a much more powerful position, even if we come in as trustee, because now we understand better what's going on and how to move the titles under trust. And I was really thinking of changing the title of the show, because the title of the show is Money, Banking, and Trust by Moving Titles in Commerce. No, it's not moving titles in commerce that I want to do. It's moving titles in trust. And I thought, that makes better sense. We're moving titles in trust, not titles in commerce. Because as private citizens, real people, we're going to be moving the titles in trust. As debtors, under debtor creditors, we'll be moving titles under in commerce, but that isn't going to do anything. That's going to be using a set-off, and all that's going to do is create more debt upon debt. And then where am I? Same place. So So if I move titles and trusts, I'm really doing a discharge. When I do a discharge, it's zeroing out the debt.
To control commerce.
Yes, yes. In fact, I'm not even doing commerce. Not even doing commerce. Under trust, I wouldn't have to do commerce.
To control the commerce they're trying to bring it up.
Yeah, I would be issuing interest that was drawn on a foreign source, and the interest I would be, if you want to call it doing commerce, I guess maybe you could, on the public side, that I would be making my payments for my goods and services to support the real man through that interest that was generated. So I guess it just depends which way you want to look at it. I'd like to look at it that I was strictly from the private side. I'm doing discharge, controlling commerce. They might be from the other side. It depends on which way you want to look at it, I guess. But yeah, I'm in control of both sides. Let's put it that way.
Yeah.
So any other questions? Yep.
Thank you.
Another comment? Anybody else have a question? Press star 6. State your name, where you're from. Hello, Fender. Say again, I didn't hear you.
This is Paul. How you doing?
Paul, hi. Go ahead.
Now this master file that you're speaking about, is there like an IRS form that we would fill out and adjust the information in that file?
No. As far as I know, there's none.
Okay, so you'd have to send a letter, a private letter?
Yeah, you're probably going to do a Treasury Directive 25-06, which is a calling of a DIB hearing. And you're going to order them to do the correction on the file. That's Treasury Directive 25-06. I'm probably going to claim that USAM Manual 6-4.010 and tell them they got to comport the records. We give them probably the 120 days under international law, and if I didn't hear anything back from them, then it would be confirmation. Then I would do all notification of all parties, give them notice, and it's a done deal.
And what would be the notification of all parties? Which parties would those be?
Just about everybody that's important that I can think of, and that might be about 25 different entities. Department of Justice, Department of Transportation, all those governmental entities. I would want to maybe send them notification.
Is there some place that has all of this?
The past recordings, especially since we started on NTT as New Trust Technology, that would be on the audio downloads starting like 11/7. So that's the month of November and December and forward.
Okay.
And if you don't have the links of the audios, send me an email at moving titles, that's one word, movingtitles@hotmail.com. Not Hushmail this time. Send me a request at hotmail.com.
And that's regarding this IMF.
No, ask for a request of the download links.
Right. Yes, I understand that.
Okay.
That discussion is about the IMF.
Yeah. Well, the IMF is more recently, like in January here. But really, you need anything from NTT starting in November, the start of 1st of November, as Big Trust Technology, to get you up to speed.
Yeah, I've been listening.
Okay, I'll email you those links. I've been studying your older links, catching up, and
yeah, the ones prior to November are all debtor creditor, and except for value and things. And I've switched and gotten away from all that.
okay, I'll email you later. Thank you for the response.
Thank you.
Okay, any other questions? Can you hear me in the meeting room there also? Can somebody put a message on the, if you can hear me, and you're in the meeting room?
I can hear you, Christian.
Okay.
Christian, this is Eric in Florida. How you doing?
Hey, Eric. Good.
Hey, how do we determine how we comport the UCC to our state rules?
All right, here in Florida, that's easy. All you do is take the UCC and put a 67 in front of it. And then take the height count, put a dot. And then usually the last number, you add a 1. So if I have UCC 3-501, for example, that comports to Florida statutes under 673.5011.
Okay. So, for example, UCC 9-336 would be 679.3361.
I think so, yeah. You might want to check it out before you use it today.
Okay.
I'm not sure whether or not the rule is that you add a 1 to everything on the end, but I know that the other is correct.
I had an interesting development recently with a mortgage company that I'm trying to get them to produce the evidence of trust, the promissory note. And I was talking to somebody in their executive office handling my case, and she said, "Well, Fannie Mae is the investor in the loan." And I said to her, "Well, you're the one who's demanding the money from me every month. So if obviously you can tell me where the note is. You must know because you're demanding the money. You have to have evidence of the debt." And she said, "Well, I'm working on that." And then I said to her, "So if you can't tell me where the note is, who can?" And she said, "No one."
Right.
So, of course, I thought to myself, well, this is the opportunity to drive the truck right through this and express the trust, because if they don't have the note, they can't express their position. And this is a great opportunity to quell this whole situation before it ever gets to court, before it ever becomes an action in court.
Right.
Right. So that, okay.
Have you done debt validation under 9-210A4?
I did a notice in demand through a notary representative, but no, I didn't do it through 9-210A4. But I'll be sending one of those now, 9-210A4. So I can make that presentation with citing the UCC instead of the Florida rules.
Yes, you could, yeah. I might not even want to I didn't put the actual statute under UCC in there. I just used the meaning of it.
The text from it, you mean?
Yeah, I didn't use it exactly verbatim, but I did exactly what the meaning was. I asked for a statement of accounting within 14 days, and I specified in there that if the debt was 0, and if they don't respond back in 14 days with a rebuttal or information that proves me wrong, then it's certified that it's 0. And plus, it also forms them into a dishonor because they didn't respond. And that dishonor I would use as the unclean hands doctrine, which is sufficient enough to knock anybody out of court.
And in addition to that, because I sent them a notice in demand with a opportunity to respond, and they failed to, I got I also carbon copied it to the about 5 federal agencies, and one of them being a punctual currency, which now I have a case pending with, because I got the letter today. So I'll give them until the 18th of January to respond to the qualified written request, and then I'll utilize them to follow up on it as well.
Great.
So I'll be happy to keep you posted. But in order to express, since she said no one knows where the note is if she can't produce it, then would it be best to send documentation to express trust, or simply do the debt validation, give them the opportunity to fail to respond, so it creates an estoppel and unclean hands, and then just quit paying it, and then if they decide to take action, then express through an NOL?
Yeah, if you think you can handle another dishonor, yeah, go ahead. If you have a notary dishonor already, actually any certificate of a notary dishonor is going to form the unclean hands doctrine.
Okay. Actually, I haven't sent out the notice of fault and the dishonor yet, but I'm going to over the next week because the time frame has come and gone by 10 days now.
Right. So any certificate generated by the notary on the dishonor from any entity is going to prove that non-response was an act of fraud because under U.S. versus Twill, they had a duty to respond. They didn't. That's an omission. Omission is a fraud. A fraud is unclean hands, violates the unclean hands doctrine. So now they can't come into a court of equity and foreclose on you and ask equity to take your property from you when then they themselves are not operating in equity.
And then if they were to bring that claim into the court, then they would be subject to the Federal False Claims Act as well, right?
Yes, I mean it opens a whole can of worms, and I don't think they really want to go there, especially if they know they know that I know how to enforce it from there. The point I wanted to make was back up a little bit when you said that they don't know where the note is. I think they know where the note is. They're just not going to say, because when they produce that note, if it's been endorsed or altered in any way, or if it's been proof that it's securitized, under the 9-336, that's proof that it's being commingled, and commingling in a trust, that's breach of trust. But since you didn't express it to be a trust, you can't say it was commingled then, unless you claim it to be a trust and prove that there was a trust. Once you did that, you could use that alteration on the note, an endorsement, say, or anything with markings on it, to be the proof that they commingled the funds, and that commingling is a breach of trust. And then we can come back in with all this other causes of action for breach of trust. That was the one on page 65 that I mentioned a little bit earlier. 65 in the book.
Is that Gilbert's?
Yeah, Gilbert's. Well, this was under trust purposes. It's cut with two, the impermissible trust purposes. So anything that's used, I'd say, against a trust is impermissible, really. And I was thinking this in like an opposite. So, but anyway, it's going to generate the fraud. And then that was under A. And then under number 1, it says that the transfer is fraudulent, so there's a fraudulent transfer cause of action. And 2 then is also listing a cause of action being unclean hands under section 229 on that same page. And then under B, unjust enrichment as a cause of action also. And then so the bank has really, there's not an equal ground or equal footing here. You're at a disadvantage because you're an individual. You don't have the skill and knowledge that they do as banks. They got all the attorneys. And really, it's an unfair business practice. An unfair business practice, so that's another cause of action. And that also includes fraud and misrepresentation and unconscionable acts and poor practices against consumers. So if you have an unfair advantage under an unfair business practice, really they're impeding commerce. And impeding commerce, here's the big one, is really monopoly and antitrust. Because anytime you impede commerce, you've got a monopoly. It's commerce by a lack of the economic competition. So they're controlling commerce by having a superior hand, and that's not fair. That's antitrust. That's a monopoly. And that brings in criminal actions. So now you got a lot of powerful stuff. And it's all based from trust. And that's on the colorable side, on the public side of the court.
So these could all be considered like counterclaims. Yeah. For a counterclaim.
Keep in mind that would have to be based on a statutory trust.
So I would have to express a statutory and a private?
To keep it colorable, yeah, quite possibly.
And it's within the the realm of the situation to express both of them in this same case?
It could quite possibly be the way to go.
And the statutory trust that I would express, give me an idea of how that would be structured and indentured. Just a few basic points, or however you want to communicate that to us.
Just the same as we've been talking about. We have the 4 elements, and we have one of the methods of formation.
Is that something that can be done orally on the public side of the court, or is that something that needs to be done
Yeah,
right?
you could do it orally, but I think I would be better off if I might want to put it in, a motion written.
And then bring it up orally in the court and to drive home the points of it.
Yeah. If I want to come bring in an antitrust, it might require the colorable trust on the other ones. You might get away with, maybe not expressing a colorable trust. Colorable trust being statutory trust. So it's like really getting our heads wrapped around this duality all the time, and the multiple trust we're forming. That's a hard concept for some people to grasp, because we all think it's all one thing. No, it's not all one thing. That's why they're really confusing us. There are multiple trusts, trust within trust. There's this division between public and private, and then there's this kind of like this sliding back and forth, so to speak, it looks like.
It's really just another manifestation in nature, because if you think about the representation in China of yin and yang, there's a little bit of light in the dark and a little bit of dark in the light.
Yeah, right.
And an equal amount of both. So it's really just it's really the perfect representation of nature in our business dealings and commerce.
Right.
And when you say in this context, as far as duality, did you mean the statutory and the private?
Yes. Mm-hmm.
Okay.
Which is hard for some people to get their minds wrapped around, because they've been so accustomed to, thinking just one-sided, one-tracked. But, a train track, depends on how you look at it. It's got 2 rails on it. It's got public and private sides, so to speak. Yet there's one train track.
Could the statutory present an NOI of the private?
Yes, with the SOI.
Okay. So a private could be contained within the statutory?
I would be on in chambers, though, for that.
Right. We wouldn't want to announce it in the public, but would the private be contained in the statutory? That's really what I'm getting at here. Or would they be 2 separate?
Well, maybe
separate?
in the motion to say that, with an instruction to go into the private and have its expression found there. Otherwise, that'd be commingling, and I wouldn't want that private trust to show up any place in the public.
Okay. So there's no way the private could be within the statutory, because it would be commingling.
Right, commingling, yeah. Oil and water.
Okay.
Be waiving the trust then. If you brought them up,
we'd be violating 90.501 through 510 here as well, right?
Yeah. Yeah.
Okay.
9-33.
And then we would give up our rights to the private, because otherwise it would be too much truth for the court, as you've expressed before.
This as in the evidence rules under 90.506 and 507, according to Florida. 506 is a privilege with respect to trade secrets or CCI information, really. And 90.507 is waiver of the privilege by voluntary disclosure. And you voluntarily disclose it by speaking about it in the public side of the court.
Now, on the dishonor that we can do to a notary presentment, we can add a true bill to that for damages, correct?
Yes. Now let me see if I can remember where that was. It's in here someplace, if I can remember it.
Are you looking at Gilbert's?
Yeah, Gilbert's, yeah.
Okay.
That was where we were talking about one time about the holder in due course. I think it's around that area. Just talking about putting in a bill.
Now, once we get that true bill, and I'm sure you'll find it in a moment, you have something while you're looking for it?
Yeah, well, here's something that just ran across here. Here's our equitable conversion right here under Section 220. That's one thing.
And how would that apply in this context?
That's one of the causes of action.
Okay. Well, okay. Now, once we have that true bill, and once we have our initial presentment, our notice of fault, and our notice of dishonor and true bill, of course, we would record that to the public record, because then we have our witnesses. Once we do that, of course, that would create an estoppel and push them into unclean hands. So if they did try to bring a case in court, we would they'd be filing a false claim. But also, the next thing that I'm interested in doing is utilizing that to create a lien against them to further discourage them from taking action. And would we want to do that through trust, or would we want to push them into the creditor? What is the better way to do that because of the fact that...
I would utilize the certificate that you generated on the public side that generated the unclean hands, because from that, then I could go into a temporary restraining order or a preliminary injunction, and that would lead to a permanent injunction. And there's your estoppel from them, from anyone that you would have a permanent injunction against to bring any further actions in, and that's per court order.
But in order to get that permanent injunction, I would either have to file or wait for them to file?
Well, if they got you in court, it'd be very easy, because now you're there and claiming the unclean hands doctrine from the certificate that was generated, you could very easily jump into a temporary restraining order to restrain the action from going, say, like in a foreclosure, and then upon a win, then you do the permanent injunction. And while the case is running, maybe a preliminary injunction.
But my basic question was, is in order to get to that point in court, either I would have to file or they would have to file in order to get in there.
Yes, right.
Okay, just at the most basic level of it. And once I have that injunction, well, in order to take action against them for legally damaging me for presenting a fraudulent presentment, well, then I could file a claim against them.
And they're 9-625. That's estoppel and damages right there.
Okay.
UCC.
And that would be the basis for my claim. But what I'm really wondering is since I could create an estoppel, well, I need to get a court order in order to file a lien against it.
If I was going to file a lien, I would do a commercial lien.
Okay. Do I need a court order for a commercial lien?
Nope.
Okay.
I don't need a court order for a commercial lien. I can sue for an unlimited amount. I'm the one who sets the damages there.
Okay. And then once I file the commercial lien, then I got to just wait till the 91st day, because then it becomes an accounts receivable.
It pays and perfected, yes.
Right. And then once it becomes an accounts receivable, what I'm interested in doing is maybe going after it in bankruptcy court and getting the bankruptcy court to force them into voluntary bankruptcy.
Yeah, you could go that way. I might want to do it a different way myself. So,
What do you got in mind?
I just put it into a special deposit and then maybe break off a chunk of that on no IDC or the 1099-C, I mean, and then have the IRS go collect it for me. Because now they're fully taxable on what the C is going to give them the
Forgiveness?
Forgiveness, yeah.
Okay.
Cancellation of the debt.
And then that way I don't have to go to the bankruptcy court and go through all the motions of that. I just let the IRS do what they do best.
Yeah.
Okay.
I mean, I could sue them for commercially for $100 million and break it off in 5 chunks and give the IRS $20 million to go collect and get them with the city, make them taxable for the $20 million. Oh, by the way, collect my 80 over here also, and I'll give you a portion of that too.
So even though the mortgage is only $100,000, I could still do a commercial lien for $100 million because they damaged me.
Yeah, any amount you want.
Okay. Did you find what you were looking for, Gilbert?
Yeah, I looked through it and I couldn't quite see it, and then I kind of got sidetracked again.
Oh, I'm sorry. I have a couple questions when you guys finish with that.
Okay, all through there?
I wonder if you're still looking, Christian.
Yeah, I'll see if I can still kind of. I know it's on the left side of the page. Oh, here it is. Bill and equity. There you go. Page 130. Section 456. For the common law, the beneficiary's interest was not subject to execution in a strict sense. The usual procedure was, and in many states still is, to file a creditor's bill in equity, or its equivalent, alleging no adequate remedy at law, that is, that the judgment creditor had sued out a writ of execution, which was returned unsatisfied, in other words, the notary certificate. And the equity court, there goes private side of the court, could then decree that the trust income, in other words, was otherwise payable to the beneficiary, be paid to the judgment creditor to the extent required to satisfy the judgment. So there's your bill there.
Nice. Okay.
And that's under the section, let's see, what section is that? Oh, that's under the alienability, again, of the beneficiary's interest.
Another cause of action that I learned about recently was, and I have to get exactly what it's cited to, is that if the lender or the bank or whatever company, when they're using this context, if they make a copy of that promissory note, it is the same thing as counterfeiting, just like doing an FRN after it's been securitized. Are you consistent with that, Christian?
Okay, read that to me again.
That once that note's been securitized, that if they copy it, that it's the same. They're now counterfeiting the security, so it falls under the federal laws of counterfeiting and the violation thereof.
Right.
Just like copying an FRN and passing it.
Now, well, if they commingled in any way by any kind of marks, they've done a conversion, which is a fraudulent conveyance, fraudulent conversion. But now they stole my assets out of special deposit.
So not only did they fraudulently convert, but if they copy it, they also counterfeit.
Yeah, it kind of reminds me of what the Bible says. It says if you broke one commandment, you've broken them all. It's like, you break one of the laws, it's like you broke all the laws. It's like a domino effect. They all come down on you. It's like one leads to another. You broke them all.
Kind of like there's no such thing as a white lie.
Yeah.
Thanks, Christian. I hope everybody don't feel like I'm hopping up the call, but thanks so much for all your knowledge.
About these causes of action is, you got to make sure you go into the legal library and do some research on them, and because all these causes of action have specific elements that must be in place, or else you don't have a cause of action. So let's say doctrine of unclean hands. If there are four elements to that cause of action, you must have all 4 elements. If you have 3 of the 4 elements, and you're missing 1 element, your cause of action will get stricken. You will not be successful in that cause of action. So you must go into the law library and do some research on causes of action and pull up whatever one you're trying to enforce and make sure that you have the correct elements there to prove that cause of action, which is the same thing as I keep saying about he who claims trust must prove trust. And that's the same thing, not under trust, but say under any other laws, whoever makes the claim must prove the claim. And they have it set up with certain kind of rules, these causes of action, that have certain numbers of elements with them, and you have to have the elements with them, or else you don't have the complete cause of action, and it won't be ruled on as they'll overrule it.
And of course, we know how subjective the different judges are in the court, so you really got to be real clear on what you're presenting.
Yes, yes. Now, if anybody wants to...
Yeah, I've got a couple questions.
Yeah, go ahead. Who's this?
Yeah, this is Kenny. Hi, Chris.
Go ahead.
Thanks for being on yet another interesting and informative call. It's good stuff. I wanted to get back to a little simpler concept, way back to something that you've talked about many times, or at least a few times in the past. It seems to be a little bit of confusion out there about this setting up the status as grantor by using an SS5. First, I want to start off by asking you this question. Who is it that you perceive as being the person that has applied for the SS5 and holds the SS5 number? Is that a strong entity or is that the flesh?
Well, I think they're looking at on their side as that being a straw man. I think that they see as fictions.
Okay. So, when someone's trying to use this form, of course, we're talking about a situation where they already have a number and they're just getting another card in order to do this, to check this status stuff. When you talk about block number 5, which is citizenship versus legal alien not, and other, does it not make sense to you, and I believe you stated this in one of the other calls, that for the purposes that we're using this form for, wouldn't you go ahead and check U.S. citizen on this?
Yes.
That's what I thought as well. You've got a lot of folks talking about writing in all kinds of other stuff and checking over. And it just doesn't make any sense to me. And I've been wrong many times before, but to me it makes sense that the straw entity in uppercase is a citizen. Although, a good point has been brought up about the straw entity not having a mother and a father, but when I get down to and I look at block 18, your relationship to the person in item 1, my rationale tells me that if I check other and specify grantor or grantor/beneficiary, it doesn't really matter what you put in block 5. Is your reasoning the same there, or am I just off?
I would leave that completely off there because, I think most people are confusing it how I made it out once before out of a totally different situation because I was not trying to prove trust. I was doing it under debtor credit, and I was trying to totally get out of Social Security. And I did that.
Yeah, I understand. But using it to set up status as grantor, using this form to do that, would you consider that on box 5 you would check U.S. citizen, and on box 18 you would check other? You wouldn't check self or legal guardian or natural or adaptive parent.
Yeah, I think that the way that I signed, because I think on the right is that where the signature line is, it says capacity.
Yeah, your relationship to the person in item 1 that's box 18. Now, if you put self, then that to me would be inaccurate because now you're saying that the person that signed it is this one and the same as the straw entity. So it makes sense to me.
You just made yourself the trustee.
It seems to me like you'd be wanting to check other and put grantor there as well.
Well, it's debatable. Let's put it that way. I would put the grantor status where I signed.
Right. But there's box 18 requires something. Well, it doesn't require. I don't know if it requires it, but there's of course 4 blanks or 4 boxes there to check. One of 4, and self, natural or adaptive parent, legal guardian, and then other. So.
Yeah, I would make that out to make it look like, it's total fiction stuff except for where I'm signing. And I'm going to sign by grantor, my name, my signature.
Yeah, so you're suggesting that people would just go ahead and put an X on self? The relationship of the signing party is self?
No, grantor.
Right, so it'd be other and you write grantor in there. That's what it seems like to me. Well, we'll move on to the next question.
Hey, Kenny, or Chris, answer that?
Yeah, go ahead.
Yeah, sure.
Hey, first, this is JC. Hi, JC and AZ. We had the same debate about that, and I think what we concluded, at least down here, was that
if you read the instructions for filling out the SS5, if you put anything other than self, you're going to have to produce documentation for both parties. So if you're willing to do that, or if you can do that, even if you're a power of attorney or otherwise, you have to produce, and that's probably going to be both a picture ID and some other kind of legal documentation that allows you to sign for that party. So rather than going through all that, it's a straw party form. It's their form. Fill it out as self. Sign it by grantor, your signature with real name, and I've done that. It came back fine. It didn't have any hiccups. I actually went in there and typed in grantor using the PDF typewriter component. Checked self because self is for the straw party. I know it's confusing, but again, it's kind of a thin line. So that was just our reasoning behind that.
Are you sure that applied to box 18 and not box 5? Because box 5 says see instructions, and you're supposed to, if you check other on box 5, which a lot of people are doing and writing in there, Native American and stuff like that, that definitely requires other documentation according to instructions. You're sure that applies to 18 as well?
Yeah, just read the instructions. It says if
Okay.
you're, like, for example, if you're coming with a power of attorney or signing as a guardian, you have to produce documentation for both the guardian and the ward.
Cool. I'll go back and review that. Thanks. The next question was with regard to taking the methods of going into chambers. The term's been used quite a bit about going into chambers with whatever documents or whatever. Could you summarize the different methods of quote-unquote going into chambers, Christian?
I don't think there's different methods. There's only one way. You have to put some kind of public motion on the public side that tells them that you've got that hearing has to be in chambers, because I've got PCI information or trade secret information.
I don't know if anybody else heard. I didn't hear you. There was a bunch of rustling going on in there. I didn't hear what your actual answer was. You said put a public motion, and what came after that?
Yeah, a public motion on the public side that basically orders the court to have an in-camera hearing. I'm going to set a notice of a hearing for an in-camera hearing. Then I would probably have to have prior into there a motion for a protective order on that CCR, that trade secret information, because that's really why we have a in-camera hearing, because I got CCI information, trade secret information.
So in camera implies in chambers, doesn't it?
Yes, if you look up Black's Law, in chambers and in camera are synonymous terms.
Cool.
When the judge doesn't have his robe on, it could be even in court with nobody there, and it can also be out in the hallway, or it could be in his chambers.
Now, the next question would be with regard to that. Are they obligated to allow you to ask for an in-chambers, in-camera hearing?
Yes, if you have trade secret information. That's the whole thing. You have to set up the trade secret information.
Okay.
So if I had a public motion that there was a trust here, and they says, well, I don't see there's any trust. Well, objection, Your Honor, we can't talk about that here because that's CCI information, that's trade secret information. We have to put a protective order on this, because the only place this is going to be talked about is in chambers. We need to have a hearing here's a motion for an in-camera hearing for my CCI information.
Right. Okay.
There's
Thanks,
where
Christian. That's
for what purpose, and restricted as to who even gets to look at it. It might be just for judges' eyes only, say. Then I would probably ask to seal the record after it's been gone over and the order has been written. Seal the records.
Gotcha. Thank you. That's all I had for right now.
Hey, Christian, it's JC in Arizona again. Kevin, another question?
Yeah, go ahead, JC.
Thanks. It's funny. I wanted to tag in right after Eric, because Eric and I have sort of parallel experiences, except his is with a charter bank, and mine's with a debt collection agency of a larger magnitude. And I was thinking about doing, well, I've run the entire administrative commercial claim process all the way to a notary certificate of default at this point, so I have that. And I was going to do actually a declaratory relief and injunctive act motion claim asking the court for certain matters. But rather than doing that, I could probably go straight into some type of a claim of the trust and do all the breaches and causes of action that you just referred to for that. So if I did that, I just ended up filing a petition to quash several summons, and in there was just one or two sentences at the very beginning of the pleading that said, comes now as, because there's three parties on there. There is the straw party, there's the respondent, and then there's also the living man coming in. So, there's a two-sentence expression that coming in as a grantor without going into a lot of detail. Do you think that amount breaches the trust and brings that into the public too non-colorably?
That's why I didn't put a whole lot of information in there. I thought that was just enough to express the trust, set up the elements, Now, the SOI to support that, there's where I would put that evidence in chambers.
Okay. I actually filed a petition to seal that pleading along with all the responses and the other affidavits that I put in there. But what I didn't do is I didn't send that directly to the judge in private because I wanted to get introduced into evidence. The only thing that did, however, was that allows the judge with court discretion to deny that motion to seal it. And so then they can bring that in. And I expressed it as CCI. I didn't do, this was actually a bit of a beta test for me. The CCI information I claimed is more relevant to debtor-creditor stuff. There was some other stuff in there about whether a person is a 14th Amendment citizen or not based on your status, but it doesn't go directly to the trust and some of that other material. So I thought this would be a good beta test in this type of scenario to see and to kind of work out some of the kinks of getting data into evidence and seeing how the court and how you go back and forth and do the technical aspects of sealing motions and or a case.
Right. On a hybrid.
It is a bit of a hybrid. So I have the feeling they're going to kind of steamroll over this as they usually do and give the government what they want. So my next step was, rather than just doing, like I said, any kind of declaratory injunctive relief, just going straight into breach of trust, causes of action, unjust enrichment. They have I have the certificate of default by the notary. They have a payment that's been tendered through an IPN. They haven't adjusted the account and they haven't returned it. So I could do all the causes of action talking about. So all this leads up to my real question, which is, if I were to file that kind of a breach of trust coming in, as a straw party, as the complainant, and maybe the living man as the living man, as a real party of interest, how much would you put into a pleading? Because you have to plead with a particularity your cause of action and set it up, and then you have the memorandums of law all behind that which then that's all going to be the beginning of the confidential information. So.
Yeah. It's like you need to put enough colorable something in on the public side of the court to give them the ways or the means to bow out gracefully, but where the real hammer is the enforcement comes from the private side in chambers hearing. Where that's where we're going to either win or lose is going to be in chambers. If you can prove the trust, and you've got the proof that the elements are there and the method of formation, then the law must recognize it to be a trust. And if you got trust, then they're in big trouble. So he who claims trust must prove trust. The success is won or lost in chambers there when you prove the trust. So really, it's won or lost before you even got to chambers. As long as you got the evidence, the records created, you can prove a trust.
one thing you said before that caught my attention when you were talking to Eric was about coming in under a statutory trust. And that's one thing that, I mean, can you elaborate on that? Because my method is just coming in as the straw party, all caps, being the either the petitioner or the plaintiff. The litigant coming in as a real party of interest, grantor. And then, of course, you have the defendant, United States, IRS, DOJ, whoever's on there. How would you come in there with some type of statutory trust? I don't quite understand that part. How would you express that?
Well, he just threw that out there. I said, yeah, you probably could do it that way, but I might want to stay away from that. Maybe just come in with something enough colorable on the public side, give them some way out to save face that they can bow this gracefully. Some kind of, some kind of thing like the unclean hands doctrine. I like that the best because that's real simple and that ties right in with equity. That way I could just stick with trust on the private side. Cause myself a lot of extra work if I, want to declare another statutory trust, and then I got to prove statutory trust, and it might cause me to maybe lose that side of the case, because more chances that goes something wrong.
So then, thinking about what you might be suing on, just like Eric and I both, we have a certificate of default and ordered protest completed and done. And right now, my true bill is 24 million euro. That's what I'm up to. And that's all for now. They keep stultifying about every single day. I get something new from those people. So I'm just going to keep adding on to it. I've done my second default on a bill, second notice in demand. So I have one more, and then that will come next week, and then done with that whole process. Let's see, with that true bill that I have existing, is that something that could be an initial cause of action that I'm suing on for, as not replevy, but just as a note and a default, and then come in with all the other causes of unjust enrichment, unclean hands, business practices?
Yeah, because every dishonor that you're going to generate from that whole administrative process is actually generating a separate unclean hands doctrine application. I mean, I could come in with a lead 4 or 5 dishonors.
Oh, sorry, go ahead.
4 or 5 dishonors, but still I've got an unclean hands doctrine, and all I need is just to combine them all on one unclean hands doctrine on the public side.
So the initial lead-off could be, or you're actually just suing. Well, it's not really an equity. You're just going to be suing over contract / promissory note.
At law remedy, the unclean hands doctrine on the public side, but which leads into the breach of trust on the equity side. I got an equity action on the private side.
Okay.
Look at the remedies of the beneficiary in the book.
Right.
The beneficiary has equitable rights that he can enforce on the private side in equity, and he also has at-law remedies on the public side. And then he also has the commercial remedies. So he's got three options. And that third option was not mentioned in the book, though.
Okay, great. So I'm sorry.
I said, was that it, JC? There you go.
That is, except where I would love to be a part of the ambassador team. I'll send you an email to that effect if you're interested in having me.
Yeah, if you haven't already, send me an email at movingtitles@hotmail.com or joining the Trust Ambassador. And the Trust Ambassadors are really going to be, a smaller group of people who want to be committed to taking us farther and studying, not just because they got their own problems they want to fix, and after they fix their problem, you'll never see them again. No, I need some people that want to go for the long run, that are in this, and willing to teach others, because one of the requirements is that you pass on the knowledge and form your own group, get your own people under you, and pass on what we're learning. So if anybody is interested in joining the Trust Ambassador group, send me an email at movingtitles@hotmail.com. This is hotmail.com, not Hushmail.
I have a question.
Okay, thank you, Christian.
Okay, thanks, JC. Yeah, who's next in line?
Question, it's Yusuf again. I just have a question.
All right.
Say, if the person's into the trust now and everything, and then they go try to purchase a house. Now, how would you deal with that? Because, you know, they're not going to let you put grantor down on any paperwork, probably.
Yeah, the
So how would you
safest
get around that?
thing is to buy it with the interest that is generated from foreign source income, which is really foreign source private account held on private. You can't do that. Can't set that up until after we've corrected the individual master file and you've effectively disconnected yourself from a U.S. business or trade. You cut the head of the snake off, or you pulled the whole tree out.
Well, that's like me now. I don't have no contract with anybody. So
I know. We're not talking about contract. The contracts are all on the debtor-creditor side.
I have no relationships with anybody right now.
Yeah. Did you ever have a birth certificate, driver's license?
I had one at one time, but then when I did a nationality change and changed all my paperwork over, I don't have them no more.
Did you correct anything in the individual master files?
I'm just
The IRS.
I'm not using the birth certificate no more.
Have you ever filled out a 40 form?
Only thing I changed, no. Everything I changed over, I changed the social over. So one name to the other.
I don't think we've been doing it exactly right, and I don't think anybody has really. I don't think anybody's methodology has really been solely trust from start to finish. Can you tell me where you might have expressed the trust?
I had a relationship with the social.
Okay. What kind of relationship?
The SS5. The social. I had a relationship with that.
Yeah, I understand, but unless I've expressed it to be a trust from the start when I signed the first time, then it isn't. It's construed to be something else.
Well, was it wrong for me to do, like once I changed the social over, I put grantor down on the application, and then I also did a UCC. I did like a notice of claim saying that I'm the grantor of this trust.
Okay, so you set up one trust that you're the beneficiary and grantor on that one.
Yes.
That's the SETI Trust. Yeah.
But other than that, people won't be able to purchase a house till they get all this other stuff lined up.
Right, I don't think so. Not to
go until your special deposit to draw the money out. Okay.
Yes, because that's how you're going to do the conversion of the private credit from the private side, because you're going to generate the interest on the public side, and from the interest, then you're going to just write a check like you would any other time out of the account to purchase the house.
Okay, that sounds good. And I also sent you an email about the ambassador.
All right.
Over there. But thank you. You're doing a good job. Everything. I appreciate your work. And thank you.
Okay, appreciate it. Hey, Christian? Yes.
Hey, Kenny, I just wanted to, it's JC, if you're still on, you might want to hear this. Just a correction. There are no instructions about Section 18 on the SS5. If he's mistaken, it's Section 5 where there's instructions on that, need to provide other forms. 18 has no instructions at all. Just to clarify. Thanks.
All right. Anybody else have a question? Press *6. State the name where you're from. Anybody else?
Hi, it's Paul from Maine.
Hi, Paul. Go ahead.
Yes, you were mentioning the OID forms earlier, and I had filed several last year. I'm getting around to I had ordered some 1099-Cs. Regarding our personal checking accounts, or checking accounts that we, have been using for years, is that something that we would use 1099 OID to generate those folks or cause the folks at the bank to put the OID back into the account? Is that something we would do in conjunction with the C?
You mean take the C funds and get it back into your checking account?
Yeah, I was fixing this week to start serving some 1099 OIDs on my bank, probably with an A form too, 1099A. And then when I got the C's, the 1099Cs, I was going to fire those off too. I was wondering if that was going to cause the bank to deposit those funds back in.
Well, I could use the C for enforcement against the bank because that's going to make them liable for the total amount. So if they would hurry up and they reconvey the house back to me, say, in a foreclosure, or give me the funds for it, that may be a bigger incentive for them to do that.
Okay, well, I'm just talking about what we deposit in our checking accounts every week. Say you put $60,000 a year in your account. And you'd like to think, and they're hypothecating that money, I understand that, but you want to get them to put the dollar back in, the original, back into the account. And this is what I'm thinking is possible, but I don't know anybody that's done it.
The original amounts, you mean?
The original is your discount. Like when you put $1 in your checking account, they hypothecate it times 10.
10, yeah, right.
So how do you get them to put it?
Tax for the conversion that they did for you, because they actually converted your signature, and they took their conversion fee, which was a 90% tax.
Okay.
Welcome to fiat currency. It's called discounting. They discounted your credit, which was the 10, but they took the fee of 90 or 9 and left you with the 1. So that 90% registration fee or that tax, you're trying to return the whole amount to you.
Right. Well, I would like to just get the 1 back, the $1 back.
Yeah, well, I was thinking previously that we could go back and get the whole 10 back because it was my signature that generated the 10 to begin with. Give them the 110 and give me the 90. But you can't do it because you didn't do expressing through the trust. Because that's where the 900-pound gorilla is. And actually it works backwards the way we've been doing on the OID because the forms are set up for them to get you work it their way, and no, we want to work it our way. When we get done with this, we won't have to be going into the court. We won't have to be doing a lot of this other stuff because we're going to do it directly into the private side of the Treasury. And we'll be calling dip hearings right in there. No courts.
So what you're saying is there's probably nothing I can do to get them.
Well, I'm thinking, the methods that we're trying to work on were really under debtor credit, and I really don't want to go that way. I want to go back, and it's like when on a ball, if I'm starting point on the top and I want to go one direction, I'm going to end up back where I started. But if I go the other direction, I'm still going to go back and end up where I started. But which way do you want to go? Do I want to go debtor creditor or not?
Well, I've sent this bank a half-page file with paperwork. I've expressed the trust as much as anybody can. They know the trust account is what it is. It's just managed by a corporation. Well, what happened was I had opened the account like 10 years ago, and it was one of those times I didn't have to use my Social Security number. I used the corporate number. And the guy at the bank agreed to do that. Well, finally, I was trying to get these people to, and I knew that was going to be a problem for me to file a 1099 because there wasn't any SS number associated with the account. So I served papers on the bank, restating what type of a trust it was, sent them the BEN, the IMY information, and
what kind of a trust was it? What kind of trust was it? It was corporate?
Yeah, well, it was an irrevocable business trust, but I had to show them the contracts between the entities, between the corporation and the trust, the contracts, to manage the account, management trust account. And this was like 10 years ago. So I tried to get them to put the OIDs back in the account. I resubmitted like 24 pages of whatever the trust information that I was sending them. And the lady canceled the account. Told me if I didn't send my Social Security number, she was going to cancel the account. And so they did. And I had to give them my SS number to open it. Otherwise, I'd have been out of business. So,
well, you suspect to connect yourself back in with a business or trade.
We'll be out of business. We'll be out of business, you know. Because she closed the account on me, sent me a check.
Right,
and,
right.
Yeah. And so now that they have my SS number, I figure I'll start 1099ing them, you know. Start doing some of this process.
Yeah. Rather than going that direction, I would recommend that I would go through trust. Well, I wouldn't do any of the debtor creditor stuff with the OIDs and that.
No.
I'm only going trust direction from now on.
Okay. Well, that's the part I'm trying to understand. I guess I've been listening to some of the other audios, and somebody was using forms on 1099B for the signature.
Yeah, anything before the November, that's when we started NTT, and I've totally switched to November to all trust stuff. Anything prior to that, that's all debtor creditor, that's OIDs and all that other stuff that I've been using in the past, and I'm no longer really supporting any of that myself.
I see. Okay. Then I'm going to have to, like I said earlier, download those recent audios and see exactly where you're working.
Yeah, November and December and January, those 3 months, bring you up to date with the NTT's new trust technology.
Right. Okay, very good. I'll email you, like I said earlier. All right, thank you.
Yeah, as I said before, our remedy is really not in debtor-creditor relationship anymore. We never was really as a secured party creditor. The remedy's in trust. It's commerce through trust and equity. And knowing who you are is not secured party creditor. Knowing who you are is grantor.
Right. Well, that was the interesting part about this little thing here. I didn't feel like I could claim to be grantor of the trust in this particular situation because I wasn't using the SS number. So it was a sticky situation. I didn't know what to do with it. That's basically what happened.
Right.
Okay. Thanks.
Christian, it's JC. I have one more comment and one more question, if I may.
Yes, go ahead.
To Kenny, if you look on page 2 of the instructions, it says important in bold. If you're completing this application on behalf of someone else, you must provide evidence that shows your authority to sign the application as well as documents to prove your identity and the identity of the person for whom you are filing the application. So that's just my response in the errata for that. And but everybody can make their own decision. That's just how I interpret it. So I did self and left it at that. My question is, when you talk about disconnecting yourself from any of the U.S. corporations or businesses and trades, as long as you express your status as grantor in any of those entities or corporate accounts, is that sufficient? Because now you're mastering your SSN, essentially, that account. So you don't have to close everything. You just have to be able to prove that whatever accounts are open, you are, in fact, a grantor.
Yeah, you might be able to do it that way. On an individual basis, I think your success rate's going to go up higher if you claim it as being trust and you're the grantor on it. But I think that what we're shooting for is 100%, and I don't think you're going to get the 100% until you go back and correct the individual master file, get everything set, corrected from the root up.
I agree with that. There's just going to be that interim period of, maybe even 6 months where you don't want to be, it'll be difficult to operate in commerce. So if you go back and say, okay, you're going to have 2 bank accounts, leave those open, you take your driver's license or whatever you need, you express those 3 or 4 several, trust agreements as grantor, you can leave those open and operate them and then go after the big root. in the interim. That was just my thought about that.
Yeah. There's an old saying that says, "He who straddles the fence winds up sitting in the middle." I think that ties in with the scripture that says, he who has a wishy-washy mind is like a cork being, tossed to and fro on the wave, subject to every whim of doctrine that comes his way. So how can you be in the private and be in the public simultaneously? Isn't that like having a wishy-washy mind? Either you're in or you're out. There's no gray areas. People who sit on a fence wind up sitting in the middle. It doesn't work. Either it's black or it's white. Choose one. Choice is yours. That's what I have to say about that.
Thank you.
Anybody else have a question or a comment? Press *6. State your name, where you're from. Anybody? Well, if there's no more questions, then...
Rick, can you hear me?
Yes. Who's this?
Hey, this is Eric. Hey, for the gentleman that was talking before the previous caller about his bank account, even if we didn't use a Social Security number when applying for a bank account, wouldn't it still be a trust relationship?
Yeah. Did you make a special deposit? A trust is formed when the trust res transfers hands from, say, the grantor to the trustee, and you got a record to prove that. Unless the grantor is the same entity as the trustee, which would be just a declaration. But anyway, record is the important thing, and it is a present transfer now. That's when the trust forms. So that's, how's that tie in with your question?
Well, I was just trying to clear up that whether we use a Social Security number or not, still a trust relationship forms when you open a bank account. That's really what I'm trying to get across, because
but did he make a special deposit?
So you have to declare it's a special deposit.
Yeah, because unless it's segregated, it's not a trust deposit, then there is no trust.
So then it defaults to debtor creditor.
Yeah. It's got to be a segregated deposit.
So because it defaulted to debtor creditor, that's why she demanded the Social Security number, because that's what they are all defaulting to, and that's really what they've known all their life.
Right.
Now I understand. That was the reason for the demand. Okay.
She was citing something about the Patriot Act and everything else, and then they had that.
Yeah, that's their colorful way of saying, but I mean, that's all they know.
Yeah.
It really, the W8 bends and the IMYs, you could maybe have used that as some kind of proof. Segregation is on page 80, section 270 in the Gilberts. The segregation where the settlor declares himself trustee, the requirement of delivery then is satisfied by the act of segregating the trust assets from other property with a necessary trust intent, or the deed may, and remember the deed is an act, the deed may take the form of a present declaration in writing identifying the res, etc. Then there's
Sorry, go ahead.
There's another section that makes reference to non-commingling, and I forget where that section is. Go ahead, ask a question. Anybody ever want to do?
So to make that a special deposit, do you do it simply oral declaration?
Yeah, as long as I said I want my pen back. And of course, it's my intent that it's my meeting, and I wanted my exact pen back in meeting. So if you're going to give me exactly back what I put in, that's a special deposit. If I want my funds back, An example was under $500 $20 bills. If I didn't ask for the exact $20 bills back, then it's not a trust. It was not a segregated special deposit. It was not a trust deposit. Had no trust.
And if we think about why she cited the issues about the Patriot Act, well, I think the whole reason that was passed to begin with is because it's anybody who's could be subject to the Patriot Act, and of course we know it's a 600-page bill or whatever it is. But under the general idea about that, it would be because they're impeding commerce.
Right, but now keep in mind we're talking about a statutory trust on the public side that we're trying to do a special deposit under statutory special deposit, which is nothing more than really debtor creditor. What we're really talking about here is a private trust making a special deposit on the private side. I only have one bank, Treasury.
So that brings up an interesting scenario. So once we express and then we're able to get to the private side of our funds and write checks from it, are we going to be writing checks directly from the U.S. Treasury, or are we going to have an account local?
I'm going to be holding in special deposit, and then on the public side, I'm going to have interest generated from the private side source.
On the public side, so then you can have a local bank account.
Yes, withholding my interest, generated on the source being on the private side.
Did you say withholding your interest?
It's not withholding, or I guess you could call it withholding. I mean, the bank is withholding the interest there, so to speak. It's holding my interest that I generated from the private side special deposit.
So you...
It's really non-withholding interest because your interest is non-withholdable.
Yeah. So the Treasury is going to deposit interest in my public side interest account, and they're going to be generating that against the private credit that is held in special deposit on the private side.
And is that what we're going to talk about in the workshop?
Yeah.
I haven't received an announcement.
On that on the private calls that we've been talking about. That was on the Monday.
Have you announced the workshop yet? Because I haven't received any announcement.
No, there's nothing released on the workshop just yet. No.
Okay.
All done and in place almost, but I just haven't announced it. Got a few things I'm trying to get done.
Start counting 120 days to cut the head off the snake.
Yeah, I believe it'll take about 120 days from that point, once we got the paperwork all done and we send all the documentation out,
Now, tonight you announced a different email address at Hotmail. What is it you'd like for us to use that for compared to the one at Hushmail?
Well, I've been having some problems with Hushmail because it's a small account and I haven't been able to send out a lot of emails in there, so I get a bigger capacity with Hotmail. We're going to give them a little bit of try, but I'm really working on something else.
One of the things I was thinking about when I was listening, and I made the calls before, when you get on for 30 or 40 minutes and lay down the premise for the call, is there any way maybe you can do that part of the audio and post that where we can listen to that prior to the call? Because if we can listen to it 4 or 5 times, we could really internalize it and get a lot better understanding of it, and maybe even have a more...
It really doesn't exist until the showtime because it spews right off the top of my head.
Okay, all right.
There's no real forethought in any of this until I'm coming in generally about a couple hours maybe before with a topic in mind. Everything is just right off the top of my head. Everything is ad-libbed right at the moment.
Well, thanks for being so spontaneous.
Thank you. Yeah, no recording exists until it's recorded. Then it is set for posterity. I'm working on a website. I have a new domain name. It's movingtitles.com. So I have email accounts I'm setting up there, special websites and everything. So any other questions there?
Yeah, Christian, this is Carlos.
Carlos, how you doing?
How are you? Hey, hi, Eric. Hi, everybody. I had a question. Is UCC 3-501, is that non-payment without dishonor? There was an attorney in California that stated that California law 2943, I think that's what it is, states that they must give you the evidence of the note, the genuine original note. And if they don't come up with that, he hasn't been paying his mortgage, according to this attorney. That's himself. He is an attorney, and he's grabbing the it's UCC 3-501. Does that make any sense?
No, 3-501 and straight UC is notary presentment.
Right. Yeah. That's what I thought. Okay. It could be a mistake then, obviously. Yeah. Well,
maybe it was another question.
Yes. I have to do a little more research on that. Okay, and I'll get back to you next time. Also, I did email you about a notice of interest. Yeah. I did not get that email back, so you want me to remind you again of that? Can we talk a little bit of that notice of interest?
Yeah, I'm just looking to see if I can pull it up here. It's just in my download file.
Okay, thanks. Yeah, I'm trying to start a foreclosure for a friend of mine coming up on the 21st. And I want to delay it a little bit so we can do a little more thinking before the trustee sale.
Okay, what was it called again? Oh, right here. That was at Northern 857? McKellar?
No.
Let's see.
I'm sure you don't recall the date on the call you spoke about that, right? But the notice of interest.
Notice of interest?
Yeah,
I talk a lot about notices of interest, so a lot of calls have that one in there.
Yeah, I know, but are they all regarding the? Obviously, they're not all regarding the same stuff, but I'm talking about foreclosures.
Well, notice of interest is just a claim. It could be a notice of interest of claiming the trust. It could be a notice of interest on, just about anything. I don't remember what it would be on, say, paying for the foreclosure, though, what we were talking about.
All right. All right, I'll sit back and let somebody else ask a question. Thank you.
Yeah, send me another email there.
Notice of visitor of affidavit of interest, or
is that what it was called?
affidavit.
That's what I had, a document of mine, or that was something you sent me?
I think you have an affidavit in mind. I think Eric mentioned that to me today. I don't know if Eric would call it that. We're talking about trying to help each other.
Eric, you still on? Do you remember what it was?
Yeah, he's gone. It's just like
I thought Carlos, what was it again now?
remember we spoke about the affidavit of interest, or signing up like a notice of interest on the property.
Yeah, I said you got to put an NOI in order to buy yourself some time so you can get into the private side.
Right.
Because you told me it was coming up quick. I said you better get it in there quick.
Right. That's what I'm trying to communicate with Christian.
Okay, so this was like to stop the foreclosure?
Property sale, right.
All right, I had an expression of the trust, which was just basically 3 lines. Is that what you're talking about? With a footnote?
Yeah, I'm talking about whatever that can help. Anything that could help.
Christian, I think what he's looking for is he's looking for some type of template with some language in order to plug in what he needs.
Well, that's kind of what I was leading to. But We put in at one time, an expression of the trust, which was just the NOI, and it was not, the first time we did it, we didn't put it in with the SOI. But if that was sufficient to knock the sale off the sale block, but then they rescheduled the sale and sold the house afterwards because we didn't come back in and prove the trust with the SOI.
Okay. Well, I don't know if you had some time either, right?
Yeah, but if I was going to do that again, say for a mortgage foreclosure, I'd come in with the NOI, which is the claim that there is a trust, and then follow it with the SOI, the proof that there is a trust.
Okay. Very good.
Then I would hold that in chambers and do that hearing that we've been talking about.
Right. Okay. So I come in with the NI. All right.
The NOI, that there is a trust, and the SOI to prove that there is a trust.
Right. Got it.
Now you set yourself up as the 900-pound gorilla, so now you can call the shots.
Very good. Thanks.
And Christian, right on the NOI, would you express your state rule that you can't disclose the private trust, and that's why it needs to go in chambers? Under CCI?
Well, I'm looking at my state rules and look under the discovery rules, and any of your discovery rules is going to be protective orders. Protective order is usually used for, we want to protect somebody from doing discovery to us, but it can be used in reverse, that we're going to actually protect our secret CCI information for disclosure. Like in Florida here, it's under 1.280, which is rules of discovery under the state rules, and then that comports down to rules under that rule, section C, which is protective orders, and then number 7, which talks about confidential and commercial information that is trade secret information. So that's where you find your protective orders under discovery.
So at the time that you submitted the NOI, would you submit a separate document that would be the protective order, or would you include it in the NOI?
Yeah, because actually when you're going to claim that's something secret, as soon as they want to talk about it, that's where I got to object, because I'm going to waive it if I talk about it in public or I bring it in in writing in the public. And I need to put a protective order. And a protective order states, hey, we can't really talk about this stuff because it's CCI. The only place we can talk about it is, and it's going to set, the motion's going to set where it can be heard at. Let me see if I can find the rule here. It's a limitation on the evidence, how it can be presented for either side in court.
But the heart of my question is would you submit 2 separate documents, or would you include both the notice of...
Could do it all in one. Could do it all in one.
Okay. Okay.
Do it all at once, but maybe with separate motions, but do it all at the same time.
Okay, with separate motions. That's what I'm getting at. Okay. And beyond those 2 things, beyond the protective order and in the NOI for Carlos at this point, would you do anything else?
Well, I've had my SOIs in also, so not just the NOI. I would combine my NOIs with my SOI, put them both in together.
So you can't file it in the case file on the public side, not the SOI, right?
No, but I could make notice of the one in existence, which is what I should do.
But you would only present the SOI in chambers. You would not present that any place else, correct?
The actual documents, right.
Yeah.
Only in chambers. But the notice on the public side, along with, say, my SOI, my SOI notice is going to be with my NOI public side, but my SOI actual documents are in chambers.
So there's an NOI noticing that there's a trust, and then there's a notice of SOI. Those are 2 separate motions?
Right. It's noticing that I have material fact evidence, a record, which is just a notice that exists, but the actual record itself is the SOI in chambers.
Thank you for clarifying that, because I don't think we ever got that much clarity on it before.
There's 1.280 in Florida is general provisions governing discovery, and then under C is protective orders. And it says in protective orders, which I'm getting down to number 7, which is 7 says that a trade secret or other confidential research, development, or commercial information not be disclosed or be disclosed only in a designated way. And that's what I want to do. So without this protective order on here, we don't have trade secret information. If it's disclosed in court, it could be waived, and I have to object every time anybody wants to talk about it. But with the protective order in there, I don't have to, because it's been given public notice that there is certain things in this case that we can't talk about in this public arena.
Can the bank use the same weapon against us?
Yes, because they'll say, oh, your discovery request is too long, too lengthy, and blah, 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 and everything else.
Right, that's exactly what happened with the qualified written request that I sent.
Yes, and you're denying me due process, discovery, and plus it's all a bunch of hogwash what they're asking for anyway, because they're trying to get you to not go into and do the next step, do the enforcement on that. Did they call a hearing on the protective motion?
They said they were not supposed to answer that. That's all. This is beyond the rest problem.
Okay, they didn't put in a motion or anything or rebut it. They just said, okay, and you don't have anything to worry about. Keep on going on your game plan. Come back in and do a motion to compel. Do a show cause hearing. Once you gave notice of 30 days, say, for discovery, they didn't come up with a note and everything you asked for, and the next step you need to do, you need to go in for a motion to compel at a show cause hearing. Why they should not be ordered to prove up what you asked for. Once you got that order from the court that they're ordered to prove up, that's the next step you need. If they don't do that one, if you get that one in there, they're probably going to say, okay, they're going to come and make you with a private deal after that point. They're going to settle out of court. If you get it to that point where you got a court order ordering them to prove the discovery, you're going to find out that bank is going to roll over on you. They're going to come back to you and they're going to make you a deal. But see, now you created the evidence that they're in a dishonor, and they don't want to go that far, so they'll put a deal on the plate for you. That's when I would ask House Act, conveyance and the title, and I want treble damages. And you guys can keep the note. And that's the only deal that I would accept.
They got no choice, man.
If the record that they're in a dishonor, on a court-ordered dishonor, they'll never let it get that far.
That's a powerful set of things to say. In order for all of us to use that information, Christian, all across the U.S., how do we comport these to compel discovery and the protective order and all those things? How do we cross-reference all across the United States in order to figure out what you just communicated that we have here in Florida? How can everybody else find that all over the place? How do they do the cross-reference?
Well, you're going to have to look in your local state rules and find out where your discovery is and your rules. And then you'll have to find somewhere in the rules where it talks about protective orders, and then go down in the protective order and see where it talks about the trade secret information. Then I would get... I have one here, Florida and federal evidence rules. And this is put out by Aspen Publishers. Now, they make one for New York, and they make one for Texas. They only make one for 3 states here, but these it's a little excellent book. It's only about, how much was it? Like $12. It's a paperback book, but it goes through the evidence rules and in these 3 states, Florida, Texas, and New York. and it compares them to the federal evidence rules. And then here's where it's going to explain to you all about what you need to know that they don't want you to know. I mean, if you did a Google under just Florida, check out what Florida has to say, and everybody on the internet can scope this out, what Florida says, because it's really comparing to the rule under Federal Rule 501, which 501 basically says, hey, we as the federal, we use the local state rules of evidence, really. So that really means hardly anything. It means you got to go back to your state. You got to go back to your own local state. So if you just did a Google for the Florida state rules to get an idea what I'm talking about, if you just Googled in 90.506 and 90.507, you're going to get privilege with respect to trade secrets and waive your privilege by voluntary disclosure. If you had this book goes over this stuff and explains it better, and you're really going to see what's in this book, even though it might be for a state that's not yours, it's still, you're going to see the light. But if you happen to be in Florida or New York or Texas, now you got the exact thing. But other states, you could get examples of it, and you have to do a little more work and bring it into your state.
Listen.
Yes.
What was the name of that for the New York?
For the New York, it's called New York and Federal Evidence Rules.
Oh, okay. I have that. Yeah. Matter of fact, I got the new one.
Yeah. Good book, isn't it?
Yes.
What's yours in Florida? What's yours in New York there?
Right. Mine's with New York.
Did you ever look at where the rules for privilege or respect to trade secrets is there?
Okay, I didn't check that because I know that's under CPL 3100 area. Let's see if I can look up.
And this one it says Article 5, privileges. It was like on page 105 of my book, but yours is probably going to be different.
While he's looking that up, can I just go ahead, Harold?
I say you can go ahead on while I look that up.
Okay. Now, we're very fortunate here in Florida because it's a judicial state, but when Carlos Bruce...
Yeah.
So the order could be quite complex then. You got to think of all these things.
Uh-huh.
Do you have any samples of a notice of or any sample work that is available any place or that I might have not know about? Or did you say you have a private call on Monday? Maybe you cover it there.
Yeah, that call's been more for non-negotiable instruments, really.
Well, that's what I've been doing.
Yeah, really, we have. All of us have been trying to do the non-negotiable stuff, but...
And that's what I put the notice... I mean, that's my agreement or trust agreement is all about, is just on that. Is there a way to... Can I email you for the number for that call?
Yeah, go ahead.
Okay. Thank you.
That's in my new mailbox there, movingtitles@hotmail.com.
Yeah, thank you. That was all. It was just really concerned how you separate, get organized with all that stuff. Who can see how much, where, yeah.
Yeah, I would just keep between the parties, I would send copies of the originals between me and the party that I have the action with or something. And anybody else, the third-party debt collectors, I'd be just sending them notices that it's private. And if you want to join in on this, I'll join you in on this claim. You can be in my trust.
Yeah, but if there's attorneys for the plaintiff, right? Attorneys for the plaintiff, and let's say I went back, like this latest one, I went back to the plaintiff CFO of that company and doing a private process with them now because they have not honored anything I've done. I've been through everything, through the motion. They never got. Granted, it's the first one I ever did, so I didn't know really how to. Probably when I was at the motion hearing, this was the second one, I should have said when he said, I'll get back to you, when they didn't show up, and it was a show cause hearing, and I stood outside as beneficiary claimant and said, can a beneficiary claimant participate in the proceedings today? And they said, we can't hear you, come in, you know. And I just said it 3 times. The third time he was silent. And then I said, let the record show that the trustee has not shown cause. And I remember exactly how I said, why this should not be, this matter should not be settled and closed with the claim. And something like that. But anyway, the point was that he said that he would let me know, and then I appointed the magistrate as the agent for the trustee. And he said, I'm the magistrate, so I thought that was acceptance. And then to bring forth the claim and to ratify it. And then he said he'd let me know if it's 30, 60 days, because it was so convoluted that they set the motion actually one day after the 90 days of the certificate of protest. So, and I accepted that on proof of claim.
Time out.
Huh?
It timed out in 90 days.
Yeah, it timed out, but they did it on purpose. They set the motion hearing for one day after. They waited they kept stalling and stalling. I kept calling, and it was in there, and so I
retimed it, resubmit it, retime it.
Yeah, so that's basically what I did. Well, first of all, I accepted the motion date on proof of claim that they were not damaging me substantively or procedurally, because of the process, of the time of the process, the date. And then, but I also then put in a new instrument, and on top of what he put on top of the motion, and used that. And had a notary surprise them from across the court, actually hand-delivered a copy of it to the judge as a magistrate, and sent the other back to the attorney. But I should have been doing it with the CFO, not these clowns. And so when I stood outside, though, he said he'd get back to me in 30 or 60 days, even though it was a fresh claim in there, and I was thinking I would need that time to do the administrative process, so I let him get away with that. But actually, I think I could have said right there, why can't you make a ruling right now?
Yeah,
he's not here. He didn't show up, So they defaulted all the way through. So this was like right in front of their face. They defaulted, so I should have asked for a ruling right there, right?
Yeah. Didn't force the issue.
Huh?
Didn't force the issue.
Yeah.
Didn't claim.
Yeah. The issue is that they didn't show cause, not that whether my claim was good or not. I should have got the motion on because they defaulted. There's different ways you can win, right?
You can have multiple processes running.
Well, I think there always are multiple processes running without you even realizing it sometimes.
Yeah, it's all a trust, but we never claim it to be a trust, never prove it to be a trust, therefore we can't enforce it under trust, so it's debtor-creditor, and then we can always come in there and litigate it.
But I mean, I was trying to always prove it, but at the same time, by them not showing up, isn't that proof that they defaulted?
I would say so, yeah.
Yeah, so I should have
certified and got an order or a judgment from that.
Yeah, I don't know exactly what I would have said, but just do you have a reason why you cannot do a ruling right now? You know, then wouldn't he have to answer that?
Perhaps maybe there's where you ought to pick up and do enforcement on that issue alone.
Well, it's timed out because he never got back to me. And so then they came back with, they just proceeded it right along and did the next step, which was garnishment, salary, you know, income execution. So they're on their next step. So I think I made another mistake. So this time I went back to the CFO, but I copied the sheriff and the attorneys copies of that private process. Should I not have done that?
Well, that'd be okay. I mean, if they're waiving their end of it, that's fine if they didn't object.
What do you mean?
If theirs was the guy on their end, if they didn't object, then if you copied it, you know, they would be waiving on their side.
I don't understand. I don't understand what you're saying. If I started a private trust with the CFO now, but I gave a copy to the sheriff and gave a copy to the attorneys and to the old magistrate, so that
Gave copies of your trust.
Yeah.
I wouldn't have given my exact copies. I would have gave them a notice.
Yeah. You have a sample of you know what that is, but in order to stop the sheriff, wouldn't you from going ahead when they don't really have authority if this is in process and you can show it's in process? Don't you want to show that?
Well, first of all, back up to where, you know, if you're going to claim the trust, have you proved the trust? That's the point. Because if you're in process of proving the trust, I mean, proving the trust in essence is showing them that you have the agreement that you're making, and you have the substantive. Proving the trust is having the records that I have the grantor's intent and purpose, that I have at least two of the parties of the three parties, and then I have specific trust res that I can prove that it was a present now transfer to the trustee from the grantor. And then I can prove that I had one of the four methods of formation, either it be a declaration or a transfer or an appointment or a contract.
Yeah, I mean, appointment is one sentence. It's not, you know, I don't, a contract. That's basically it. But I gave him a copy of,
It's just like a cause of action. If I don't have the appropriate elements in a cause of action, if I'm missing one of the elements, then I don't have a cause of action. And it's just like a cause of action. This trust has certain elements, and you must prove those certain elements in this cause of action being the trust.
Okay, you were speaking before about staying them from going ahead. And basically what I'm saying is I sent copies of what I'm doing to stay them from going ahead, like, you know, as if nothing is...
Full copies of everything, the whole thing, details, all the specifics, you know, of everything that you did. A waiver.
What?
Which would be a waiver. Would be a waiver on your part if you gave them full copies. If you gave them copies of all the actual documents that you were holding on the private. All I would have to do would be a one-page notice that such and such a documents exist that are held in the private, and this is a notice that they exist of a specific number, say. So I can identify.
Like a mailing registration number, and maybe I could show them the proof of the mailing with the proof of the contents
some way to specifically identify the whole process as being one thing under one number. And all I would have to do would be like one short paragraph, which would be a notice of the existence of that particular number identified by that particular number, which represents the whole package. And that'd be the one thing I would send to them, which would be a notice of the existence of the actual documents held in the private. Now, they don't get to see those.
Okay, so basically it sounds like a proof of mailing and a proof of USPS and proof of service that has the registration number on it and the content.
I want to take a more official look. I want to put it on something that says, this is actual constructive notice of existence of such and such a document held in the private, and then I'm going to take that and record it into the county, put it and pull out certified copies of it. There's one record. Put that on a UCC1, pull that back out certified. Now I've got 2 records of what I did.
Wow. Hello?
Yes, uh-huh.
Oh, okay. Well, see, do you have any, okay, do you have any sample of anything like that? That's what I'm wondering. Or you're just winging it. You're just making it up as you go along. We could do those things without damaging ourselves, whereas doing it in private like this, passing it around, then they turn around and put it in the public.
Well, if they put it in the public with a protective order, now they're in violation of the protective order.
I didn't do a protective
of the order. They don't do that.
Huh?
That's the whole purpose of the order, so they don't do that.
Yeah. I mean, you really have to put strings on every little thing.
Yeah, because these are your substantive rights of the real man and woman. And they're only, for the judge's eyes only, or only anybody that's in chambers. And that's where the real rights, that's where trust operates. Because trust is a private man.
Yeah, well, I mean, other advisors have told me, copy everyone. Let everybody know what's going on, what you're doing, that,
Yeah, that's under creditor litigation stuff, yeah. Which waive all your rights privately.
Yeah.
They love you for it. Because they get to hammer you.
Yeah, I just can't take it anymore. It's just crazy. So I really got to learn this. All these little... So, okay, thank you very much.
When we get this done, we won't even have to go into court, I don't believe, other than give them notice that it's been sent to the Treasury, and Treasury is calling a dip hearing, and you hear back from them. You'll get notice from them.
I'd like to get to that point. That would be just beautiful. But I have one question for you, because everything has really pushed me under, and I'll be getting a W-2 this year. Do you have any suggestions on how one might deal with a W-2? Would you, I mean, the idea of setting it off with the IRS is probably a good step, right?
No, I'm not going to do set off. I'm going to do a trust deposit. I'm going to do a special deposit into the account, into the trust.
Okay. Do you have any sketch?
Set off is under debtor creditor, and trust is where we want to go, because that's where we get a discharge.
Yeah. So do you have any paper on how, do you have any form or paper of how that might look with the IRS or? With
the IRS, well, it's really all the stuff we've been working on. It's really all the same model. You're doing everything the same for everything.
Okay.
And we're treating it all like a trust. Back to the elements and the method of formation.
Okay, so with that...
If we've got a trust formed already, then we're going to put it into special deposit as an asset. And then we're going to do a discharge with it under trust. It bypasses the public side, debtor-creditor stuff, litigation, and all that stuff. All that crap. We ain't fooling around with that anymore.
Yeah, it's a waste of time.
But more of that will be revealed when we come out with the workshops, and we've got more on them. So we've discovered the methodology that they've been using. We've discovered the effects of how what's happened, and we've revealed the source on how to close it all down. How to gain control of both sides of the ledger, public and private, because the public side is controlled from the private side, and the private side is trust. Trust is controlling both sides.
Yeah. Is this call being recorded?
Yes, it is.
Great.
Okay. Anybody else with a question? Maybe one more, and then we'll call it quits. It's getting kind of late.
Thanks.
JC?
Yes, JC.
It's Pete.
Pete? Hi, go ahead.
Hi. Just a comment more than anything, just an announcement to everyone who's on the group. There's already a group set up on Skype. If anyone wants to join it, they're more than welcome. We discuss a lot about this type of stuff all day long.
Okay. And announce the group?
Yeah, if you contact me on Skype, it's Cheeky Monkey and then the number 1. So it's CHIKIMONKI and then number 1. It's Michelle just got up.
Okay, tell her hi. Okay, tell her hi.
Yeah. Okay, that's about it. Thanks a lot, Christian.
Okay, Pete.
Wonderful show again.
Pete, there's one thing I wanted to ask you while you're on the line here. Trying to get a hold of... We have the first American edition. What we need to do is go back a little farther of 1888, the Law and Trust, and we're going to go back to 1776. Well, American jurisprudence is based on English, and this first edition of the Law and Trust was taken from the 8th edition over in England. So could you maybe check out and see whether or not, how far back do we have to go, like maybe the 7th or the 6th edition to get back to about 1776?
I'll go to the library later today. So is it Bogart or is it Gilbert or which one?
It's the one that's been floating around by Lewin.
Could you spell that, please?
I got a copy of it. I can send it to you if you don't have it. It's Lewin.
Okay. And it's called?
A Practical Treatise on the Law of Trust.
Yeah, I'll hunt that down.
Because that was an 1888 version, which is the first edition in America.
Yeah.
But that's based on the 8th edition from England. So if we want to go back to, say, 1776, we'll probably have to go, since this was the first edition in 1888, we'll probably have to go back to England and get like maybe the 7th or the 6th edition over there to see how that comports in at 1776.
Yeah, I'll go to the Central Library tomorrow, later on today, and I'll check that out.
Because really it's fee, fi, fo, fum, and we're back in feudal fiefdom.
Yes, very much so.
It's all about trust.
Yep.
Also, another thing I want to ask you, the correct year for John Waltham, the Bishop of Salisbury, who was the Lord Keeper in the reign of Richard II. He originated the writ of subpoena. Do you happen to know what year that might be at?
I was reading about Richard II earlier. What is it exactly that you want to know about?
Well, I just want to know, I'm curious about the year of Richard II, because this Lord Keeper, Bishop of Salisbury, John Waltham, about what year it was that he came out with the writ of subpoena. You know, I've always wondered why they have summonses and subpoenas. I know why. Because the summons is not just for the original complaint. The summons is for the corporation fictions. The subpoena is for the real man to use. That's where you summon into chancery the trustee and swear him in under oath to answer to the allegations of the Seti Key Trust, the beneficiary of uses.
Yeah, We found, in the group today, we found a really curious looking website, which was the official solicitor.gov.uk, and it's associated with the public trustee.
What I was asking was, you know, the year for the reign of Richard II. When did he come out with the writ of subpoenas?
I will check that out, definitely.
Because that's when trust first started appearing. That's the origin of the trust.
Cool.
I thought you might be the best one that would know that.
Well, I'll definitely check it out, and I'll not stop till I get the answer for you.
Okay,
and I've
thank
got
you very
some
much.
real bloodhound friends as well now on the group.
Say
More
again?
than welcome.
Okay.
I've got some real bloodhound friends in the group, in the Skype group.
We'll put them on the scent trail.
Will do.
Okay. Why don't we call it a night? So today is Tuesday. I'll see you all tomorrow night on TalkShoe, and that number is 724-444-7444, and the PIN number is 41875#. And that's at 8 o'clock Eastern Time. We'll be continue on in the Gilberts. I think where we're picking up as we're going to be talking about trust res. So I'll see you all there. If not, I'll see you on Saturday at the regular showtime on Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Thank you all for showing up, and have a great night.